Good morning, Mr. Logue.
Good morning.
May I remind you that you're still subject to the oath that you took on the previous occasion? Ms. Thompson.
Good morning. You are John Logue and you are the Crown Agent and Chief Executive of the Crown Office and Procurator Fiscal Service, and you gave evidence to the inquiry on the 23rd and 24th of April of this year.
That's correct.
Thank you for returning to assist us further. You will be familiar by now with the blue folder. I see you have already opened that up, Mr. Logue, and we should find within it a second Rule 8 request that the inquiry sent to you on the 22nd of April of this year. We don't need it on the screen, but the reference number is SBPI 00590.
That's correct.
Is that there?
Yes.
And we should also have your response. This we will bring up on the screen, please. Your response is SBPI 00605. And if we scroll to the bottom, please. It appears that both your signature and the date that you signed it have been redacted, certainly from this version, but I understand that you signed the statement on the 17th of May of this year.
That's correct.
And I'm hoping that the copy in front of you will have both your signature and the date on
does.
it. Thank
Yes.
you. And as with your previous Rule 8 response, you concluded at the inquiry's request with the words, "I believe the facts stated in this witness statement are true. I understand that this statement may form part of the evidence before the inquiry and be published on the inquiry's website." And so you prepared and signed your statement in the knowledge that it would be evidence before the inquiry and would be published on our website.
That's correct.
Did you do your best when answering the questions that were asked of you to provide a true and accurate response?
I did.
This is strictly speaking a response to a Rule 8 request, but for convenience and by way of shorthand, I'm just going to refer to it as your statement as we go through your evidence. You were asked in the Rule 8 request what is your understanding of institutional racism and what makes an organisation institutionally racist. And in paragraph 2 of your statement, your Rule 8 response, you answer that question. It's quite a lengthy answer, but what I would like to do is read it out in full and then ask you some follow-up questions. So you say, "My understanding of institutional racism is informed by the definition set out in the Macpherson Report, 1999, which I regard as the definition adopted by COPFS since it was first published. The report defined institutional racism as follows: the collective failure of an organisation to provide an appropriate and professional service to people because of their colour, culture, or ethnic origin. It can be seen or detected in processes, attitudes, and behaviour which amount to discrimination through unwitting prejudice, ignorance, thoughtlessness, and racist stereotyping which disadvantage minority ethnic people. It can be seen from this definition that an organisation can be regarded as institutionally racist if it suffers from such a collective failure to provide an appropriate and professional service to people because of their colour, culture, or ethnic origin. My personal understanding of this concept was informed by the Jandoo Report 2001, which considered the liaison arrangements between COPFS and the family of Surjit Singh Chokar, who had been murdered in 1998. My recollection is that Dr. Jandoo's conclusion that there was institutional racism in Crown Office was a very difficult moment for staff who had, as it now appears to me until that point, focused on racism as a characteristic of individual behaviour and took pride in their own individual commitment to a fair prosecution and death investigation service. It was very challenging for all of us to understand and accept that we were part of an organisation which was institutionally racist and reconcile this with our own personal standards and behaviours. To this day, the concept of institutional racism at an organisational level is not well understood by the public or in other organisations, but I am proud that COPFS, led by the then Lord Advocate Colin Boyd, reacted to Dr. Jandoo's assessment with openness and a public leadership commitment to transform its approach to tackling institutional racism. This work continues to this day and has evolved to take account of important developments such as the Equality Act 2010. So you explain in this paragraph, Mr. Logue, that your understanding of the concept of institutional racism is informed by Lord Macpherson's definition, which you regard as the definition that was adopted by Crown Office. And you also say that your personal understanding was informed by Dr. Jandoo's report. Now, Dr. Jandoo didn't adopt Lord Macpherson's definition of institutional racism. He put forward a different definition, and for convenience, so that we can look at the two definitions side by side, I would like to bring up a slide from a presentation given to the inquiry earlier in this hearing by a Professor Meir from Glasgow University. I wonder if we can bring up his PowerPoint, which is WIT 100, and look at slide 22. Sorry, I think I must have the wrong slide number. If we can keep scrolling up, and I will ask you when to stop. Sorry, down a bit. There we are. Thank you. So I'm simply using this slide for convenience so that we can see Lord Macpherson's definition and Dr. Jandoo's definition of institutional racism side by side. Professor Meir also included Lord Scarman's definition, but that's perhaps less relevant for present purposes. So the Macpherson definition is as per that I've read out, as set out in your statement. Dr. Jandoo's definition is subtly different. Institutional racism occurs wherever the service provided by an organisation fails, whether deliberately or not, to meet equally the needs of all the people whom it serves, having regard to their racial, ethnic or cultural background. Now, the Macpherson definition, of course, dates back to 1999. Dr. Jandoo's definition is from 2001. And I wondered why it was that Crown Office adopted the Macpherson definition rather than the Jandoo definition, given that Dr. Jandoo's conclusions were specific to the Crown Office in a way that perhaps Lord Macpherson's were not.
Well, it's very difficult for me to give evidence to the inquiry today about any consideration that the difference may have been given by Crown Office in 2001. I think all I can do is assist the inquiry by giving a personal view that any conversation I have ever been involved in the organisation where we have discussed the concept of institutional racism has always referred back to the Macpherson definition. I've always taken that personally, and I regard others in the organisation to have taken it in the same way, that was the definition. And until you drew out this distinction for me, I'm not sure that I could have told you that there was personally a distinction between the Jandoo inquiry and the Macpherson inquiry in terms of the definition. I don't remember as a member of staff in 2001 that any great significance was put on the difference in terms of the information that was given to staff about the conclusions of the Jandoo inquiry. The significance for staff was Dr. Jandoo's conclusion that aspects of the service provided to Mr. Chokar's family demonstrated that the organisation had suffered from institutional racism, and that was the critical element for colleagues in the organisation to understand and grasp.
Thank you, that's helpful. Seeing those two definitions side by side, to your mind, is there a material difference between the definitions?
So I'm not sure I'm best qualified to explain whether the significance of any difference between the two. The Macpherson inquiry definition talks about the failure to provide an appropriate and professional service. It highlights that this comes through discrimination and the factors that can amount to discrimination, and then provides more detail. That, to me, has always seemed a very helpful way of explaining to people. And any time that I have personally spoken to staff about the organisation's commitment to inclusion and equality, the references both to the Chokar case and the consequences of that, but also back to Macpherson to root it in a wider UK perspective of an issue that had a broader foundation throughout the UK.
Thank you. It may be that nothing turns on any differences that there may be between the two definitions, but I hear you say that your professional experience is that it was Lord Macpherson's definition that was effectively adopted by the Crown Office. And when Dr. Jandoo's report was published, the Crown Office's focus was on the failings identified rather than any semantics around the definition that was put forward by Dr. Jandoo and how that might have compared to Lord Macpherson's definition of institutional racism.
That's correct, and I think also in preparing to give evidence today, I'm sure the first inspectorate report, which I think might have been 2005, and of course the inspectorate was set up as a result of a recommendation from Dr. Jandoo in his report, but I'm sure that report talks about the previous Lord Advocate before Colin Boyd responding to the Macpherson inquiry. So at there was a period of time between the Macpherson inquiry and the Jandoo report where the organisation was focused on the Macpherson inquiry and taking steps to learn the lessons from the findings that Macpherson had found.
Thank you. Can we return to your statement, please? We were looking at paragraph 2, perhaps a little bit further down, please. The top of this page. Perfect, thank you. You explained that it was very challenging for all Crown Office staff to understand and accept that you were part of an organisation that was institutionally racist and to reconcile that with your own personal standards and behaviours. Can you tell us a little more about the impact of Dr. Jandoo's findings on staff and staff morale within the Crown Office?
Again, I can offer you a personal perspective on that and my recollection, which is that the Jandoo report brought home to us, and I think made real in a very practical way in the context of our work, what might otherwise have been something that was perhaps more theoretical in relation to the Macpherson report, and to deal with something that arises from the work of your own organisation, and to have someone then reach a conclusion that the organisation in which you work was institutionally racist was a very difficult thing, a very difficult time, and staff, including myself, I think struggled with how it could be possible to reflect on your own personal values but then have someone determine that you were part of an organisation that was institutionally racist. And that, I think, was a very necessary process to go through, because it did help me, I can't speak for everyone in the organisation, but it certainly helped me and others that I spoke to at the time. It helped bring home to us and make real, in a way, that's perhaps the best way I can describe it, what the concept of institutional racism was, and how, despite individuals feeling that they, in their own actions and values, do not act in a racist way, they could be part of an organisation which has practices and policies and behaviours which are institutionally racist. And so it was very much about that, bringing home to us the sharpness of that concept, and as a result of that, then the need to do something about it, and not to allow any personal feelings of your own personal values and behaviours to get in the way of tackling the concept at an institutional level. And I highlighted that in my statement because I think I see publicly still to this day, partly media commentary, partly what I see in relation to other organisations, that others still wrestle with that difficulty that I remember from that time. And so I think it can be very difficult for organisations to overcome that, what I'm describing at a personal level, in seeking to recognise institutional racism and tackle it.
In relation to tackling institutional racism, you were asked in your Rule 8 request about the efforts that have been made within the Crown Office to overcome institutional racism, and you give your response at paragraph 3 of your statement. Again, it's quite a lengthy and detailed response. What I would like to do is read it out and then ask you some questions about your response. I've described in answer to question 2 the circumstances in which Dr. Jandoo judged COPFS to be institutionally racist. This was accepted by the organisation, and very significant efforts were made to overcome this through training, engagement with community groups, increased diversity in our workforce, and structural embedding of practices which are designed to combat unwitting prejudice and bias. COPFS has a very strong and popular set of staff equality networks which raise awareness, promote improvements in our processes, and provide direct support to staff. We operate a successful 2-way mentoring scheme to allow members of the equality networks mentor senior leaders on issues associated with their network, and in turn, senior leaders mentor the members of the network on leadership and career development. I have been involved in this mentoring for 6 years, and am this year engaged in 2-way mentoring with a member of our Race Equality Network, which is personally rewarding and instructive. Our annual Equalities Conference is a very popular event at which we celebrate the success of staff in promoting equalities, review our progress, and set challenges for the year ahead. Our public speaking competition for school pupils is always focused on the promotion of equalities and is strongly supported by staff and stakeholders as a visible public demonstration of our commitment in this area. I've always believed these efforts have been successful and that COPFS is a very different organisation. It is now one in which we speak to recruits as part of their induction about the importance of equality, diversity and inclusion, a process in which I personally will remind recruits of Dr. Jandoo's conclusion in 2001, and in which we are vigilant to ensure we are never again judged to be institutionally racist. We also benchmark ourselves externally, currently through the Employers Network for Equality and Inclusion, ENEI. In 2023, we achieved for the first time the gold standard in the ENEI Talent Inclusion and Diversity Evaluation, TIDE. This is a benchmarking tool which is used to measure our performance in diversity and inclusion across several areas, including workforce, strategy and plan, recruitment, training and development, and procurement. We were then compared to other organisations taking part. Our overall score was 87%, which placed us as 10th out of 171 organisations. COPFS scored particularly high in our workforce, strategy and planning, and leadership and accountability. So here you describe the Crown's acceptance of Dr. Jandoo's conclusion that Crown Office and the Procurator Fiscal Service was institutionally racist, and you set out the steps that have been taken in the past 20 years or so to eradicate institutional racism, and they're listed at the top of that paragraph. If we could perhaps scroll back up to the top of paragraph 3, please. And the first that you mention is training. Can you tell us a little more about the training? What does it cover?
So I think I spoke a little about this on the previous occasion that I gave evidence, but the training has evolved over time. In the 2000s, the training is very much focused on the raising awareness of the concept of institutional racism and the learning from the Chokar case, as well as a much broader attempt to raise and promote equality, and at that stage my recollection is it was very much focused on the question of race. And as we began to prepare for the implementation of the Equality Act in 2010, we then broadened that effort, and our training took on a broader look at inclusion and equality, not just race, and a range of other protected characteristics in the 2010 Act. And it was an attempt to comply with our obligations in the 2010 Act, but also begin to build a much stronger awareness of the need for equality and inclusion in our work. And there were elements of that training which were mandatory, and forgive me, I forget the titles of the courses, but they were mandatory training courses at the time for all staff. And as I think I said on the last occasion, there were also training courses targeted at managers and leaders to ensure that they understood their responsibilities to tackle any issues of equality and inclusion which they came across. And
these training courses include race?
Yes, in My recollection is that in the 2000s there was very much a strong focus on race because of the consequences of the Chokar case and Dr. Jandoo's findings. And as I say, my sense is that after the Equality Act, we broadened that focus to look at all protected characteristics and the need for broader inclusion and equality.
Do the training courses cover Article 2?
From my own recollection, I can't remember. I would need to check within the organisation on the detail of what was included in the training. I don't know if any of it's been made available to you or not. But whether it was that training or whether it was training through a focus on death investigations, I do remember at the same time a strong focus in the organisation on the consequences of Article 2 for our death investigations.
What about Article 14? To your recollection, was that covered in the training?
I can't remember the specifics of the training and the detail of the content, but I would be surprised if it were not covered in the training, given that we had very recently also undertaken a very significant training exercise in relation to adoption of the Convention in 1999 and 2000. Again, all staff were trained in a mandatory fashion in relation to the adoption of the Convention, and I would be surprised if the equalities training in the 2000s didn't make the connection with Article 14, but I just simply can't remember personally at this stage.
And how was the training quality assured?
That was done through, at a simple level, assessment by everyone who attended the training. There was a strong focus on managers supporting staff who had attended training, and I think also through a group, a steering group, I think, which was led at the time, they would assess a range of information from across the organisation, such as information from HR about grievances or other staffing issues which might be related to questions of race. I can't remember when it started, but every year the civil service across the United Kingdom carries out a staff survey in October of every year. I can't remember when that started, but that also has questions in relation to equality, and it also has direct questions about individuals having suffered harassment or discrimination. And that became another data set which was used to evaluate the effectiveness of our overall approach, including our training.
Thank you. Was this training supported by guidance materials?
Yes, I believe it was.
Would they be on the knowledge bank? We've heard a lot about the knowledge bank from your colleagues.
So I think it's important to remember the period of time that's passed. So the knowledge bank didn't exist in the 2000s, and if we're talking about training delivered in the 2000s, that would very much have been delivered face-to-face with material provided at the training events for individuals, either in advance to read before they came to the training events, to consult during, or to take away for reference after it.
Okay. Returning to your...
There was, just to be absolutely clear, I should be clear, although the knowledge bank didn't exist, there was an intranet, an internal website, but it was much less developed than it is now, and I don't remember the knowledge bank being available in the 2000s.
We've heard that there was the Precognition's handbook, guidelines on serious casework, I think, and the deaths manual of practice. Are these the sort of places that Crown Office staff might have been able to look for guidance materials that touched on issues of equality and diversity back in the early 2000s?
Indeed, in relation to specific tasks, and these are sources that you're referring to which trace their roots back to essentially hard copy folders of guidance which either every member would be given, a member of staff would be given, or they would have access to within their office. And the time that you're asking about was a time where we were transitioning away from hard copy, which was hard to ensure it was kept up to date, and we were therefore moving to trying to digitise as much of our guidance as possible.
Returning to your statement, in addition to training, you mentioned engagement with community groups. Can you tell us a little bit more about that?
I wasn't personally involved in that at the time because of the role that I occupied, but it was very clear to me that Colin Boyd as Lord Advocate and his successor as Lord Advocate, Lady Angelini, placed great store on procurators fiscal overcoming what you might have regarded as a traditional distance from local communities, and overcoming that by engaging directly with different community groups. And given the focus on race at the time, a real effort was made to focus on local community groups who supported minority ethnic communities in Scotland, and to work with them to help them understand the work that we did, to build up relationships with them, and that would also allow individuals to answer any questions that the groups might have. We also sought to involve the groups in our work and to bring them into the organisation. And I remember a very strong focus on the, at that stage, we were divided into 11 geographic areas with an area procurator fiscal in charge of each one. And there was a very strong focus on the individual leadership of the area procurator fiscal, building those relationships and getting to know those groups. And so I remember examples in Glasgow and Lanarkshire where that was done quite successfully.
Thank you. You mention increased diversity within your workforce. What steps were taken to increase the diversity of your workforce?
That my understanding of that from the time, and it continues to this day, is very much about raising awareness of careers within the Procurator Fiscal Service, targeting that raising awareness at minority ethnic communities, and doing that alongside our other work to give them the confidence that this was an organisation that wanted to change and that prioritised equality and inclusion. So it was very much about trying to engage with people where they were, which would, in terms of careers for prosecutors, would be at universities, but also going into schools as well at a much younger age and raising awareness. And there have been examples over the last 20 years of individuals who have joined the service who have said they have joined directly because of engagement like that. And that's why, to this day, I mentioned later in the statement, every year the public speaking competition is targeted specifically on the subject of equality.
You say elsewhere in your statement that your data from March 2023 says that 3.8% of your workforce identifies as being from an ethnic minority background, which was broadly in line with the census data from 2011. You may or may not be aware that the 2022 census data have been published very recently, and 7.1% of our workforce or people of working age in the UK identify as being from a black or ethnic minority background. Are efforts ongoing within the Crown Office to continue to increase the diversity of its workforce?
Very much so, and I can perhaps speak about two different aspects of that. So one is the need to move beyond recruitment at the entry levels to ensure that in promotion and career development that we continue to reflect at all levels in the organisation, up to and including the most senior levels, the diverse communities in Scotland. And the second aspect is the continuing focus on recruitment. So the updated census data indicates that as a proportion of the workforce as a whole, we still have some way to go to match the population of Scotland, and that therefore will remain a priority for us. But looking at the most recent data in 2022 as a year, taken as a 12-month period, for our new recruits, of all the recruits that year, I think between 7 and 8% of our recruits that year were from black and minority ethnic communities, Asian minority ethnic communities. For promotion, the most recent data I have in relation to promotion is that in a recent year, within the last year or so, 11% of the staff who were promoted were black, Asian or minority ethnic community, based on their own self-declarations, of course. So that is, I take it to be a positive indicator that while the overall proportion of the workforce continues to change, and the most recent data for 2024 is marginally increased on the figures that you have in my statement for 2023. I didn't have that data when I completed my statement, but the the figures for the workforce as a whole for 2024 show a marginal increase in the proportion of the workforce, and those figures that I've been able to give you today for recent recruitment and recent promotion, I think, give me some degree of confidence that we are succeeding in our efforts, but still with a long way to go.
You also mention in your statement the structural embedding of practices designed to combat unwitting prejudice and bias. Tell us about that.
There are different examples. So, for example, for quite a long time, the organisation has operated in all promotion and recruitment exercises. All details, personal details of candidates are removed from the information which is provided to people who take decisions, so that we can be confident that decisions which are made either at the recruitment stage or at promotion stage are made without any influence of unconscious bias or such factors. So that is one example of that structural practice which I was talking about there.
Thank you. You mentioned various other initiatives, the mentoring scheme. There's quite a lot of detail about that in your statement already. The annual Equalities Conference and the public speaking competition for schools. You touched on that already, and you explained that it has a particular focus on equalities.
That's correct.
Can you tell us a little bit more about that competition?
Yes, so the competition, I think now has been running for almost 10 years, and I can't quite remember the number of schools which compete across the country, but it might be about 100. We recently, just in the last month or so, had the final of the competition, which is supported by, I'm very pleased to say, by the Scottish Court Service, and we're able to host the final of that at Parliament House, which gives the opportunity for the children to come and speak in one of the courts in Parliament House, which they very much enjoy. But each year, it's organised through our geographic structure. So each of our 6 sheriffdoms will work with local schools and will run local competitions, which I think start around about October, November. And through the winter, the schools compete in various heats and then work their way through to national semi-finals. And it seems to be a very successful event, which the schools are very keen to promote and have young people engage in. We set the topic for the debates, and the topics are always focused on issues of equality.
Does this competition give the Crown Office the opportunity to raise awareness with a young audience, tomorrow's lawyers potentially, that there are careers to be had in Crown Office and that Crown Office is a place that encourages equality and diversity and inclusion?
It's exactly that, yes. Yes.
Thank you. So you've outlined in some detail in paragraph 3 of your statement the initiatives, the efforts made by the Crown Office over the last 20 years or thereby to eradicate institutional racism. And I wanted to ask, how would these efforts help a precognoser investigating the death of a black man in custody where race was potentially a motivating factor?
So these are very much factors I was describing from the point of view of workforce and employment. You're turning now, I think, to the question of the actual work which we do. And there, I think we do benefit from these broader issues, because although they are focused on the workforce, I think what they do quite successfully, and I've seen this now, particularly at the annual conference, they raise a very broad awareness across the whole workforce of the importance of equality. The fact that staff are given time to take part in these efforts gives staff the confidence that equalities and inclusion is something that is important to the organisation. And therefore, I think that does provide a general background to the actual casework and the investigative work, which I think is important. I think it would have been wrong for the organisation simply just to focus on the technical aspects of how we do our investigative work or our prosecution work and not have tackled these broader issues within the workforce. And it would have been wrong not to try and be clear for everyone in the organisation and for the public about the fact that equality is an important value in the organisation. You obviously then need different approaches in relation to what I'm describing as that technical work in relation to investigation and prosecution. And there we rely on the fact that we've very much since 2010 embedded equalities across all areas of our work, all areas of our work. And I therefore would expect that training in relation to individual aspects of work would be the appropriate place then to highlight important issues of equality. And if that is not there, then that would be something that we would have to correct and change.
Returning to the questions that you were asked in your statement, you were asked whether Crown Office remains institutionally racist, and you give a response at paragraph 4. Again, I'd like to read it in full and then ask you some questions. I do not believe that COPFS in 2024 is institutionally racist in the way that it was in 2001, but it is important to stress that the most important assessment of institutional racism for an organisation is an external one, and the shared priority of our leaders is to do all that we can to ensure that the public, including victims and bereaved families, minority ethnic communities and stakeholders, judge us by our actions and the way in which we engage with them. It is their assessment as to whether we are institutionally racist, together with external benchmarking as described above, which guides and motivates us. Our priority is to ensure that we do all that we can to guard against the possibility that the quality of our service we provide to a member of the public is impacted by that person's race, culture or language. The ENEI Tide guidance describes what I believe the approach of COPFS to be in the following way. Full inclusion is a temporary state few organisations will ever achieve. However, the best recognise this and understand that a drive for continuous improvement is in the best interests of the organisation, their employees and stakeholders. So you begin that paragraph by saying, I do not believe that COPFS in 2024 is institutionally racist in the way that it was in 2001. Just to be clear, are you saying that institutional racism has been eradicated or that it's a work in progress and part of an ongoing drive for continuous improvement?
I'm saying that it's very much the latter point, that it's a matter of continuous improvement and vigilance, and to work in an organisation which has been previously judged to be institutionally racist, I think, is such an important reference point for the values that you want to build in an organisation that I think it would be foolish to say that you can ever eradicate it. And that's why I highlighted that quote from the ENEI guidance, because I thought that was quite a good way of describing how I personally and how I think other leaders in the organisation feel about it, that I do not believe we are institutionally racist as an organisation, but I am not complacent, and I'm trying to signal in that answer that actually, to some extent, my personal view of my fellow leaders is less important than the views that others form of us. I often share with new colleagues in the organisation my personal view that it's not the results in the casework that we do. These are not the things by which people judge us. People judge us by the way that we treat them as an organisation. They remember how we made them feel, and they don't judge us by the outcomes. People understand that we work in a system where it's not our job to guarantee outcomes. And I think that's an important point to stress to particularly new members of staff who join the organisation, because our work drives us very much to prepare cases, investigate deaths, and to reach a conclusion. And I think if you didn't take steps to guard against it, it would be very easy for us to fall into the trap of thinking that the way in which we are judged is by the results of those cases or those investigations. And I think what comes through here in this question is my view that actually what is more important is the way that you treat people when you're dealing with them.
You quote the ENEI Tide guidance full inclusion is a temporary state few organisations will ever achieve. Is that statement essentially a warning against the type of complacency that you've described? A warning to remain vigilant?
It's very much how I interpret it, and it's very much how I see the Crown Office and Procurator Fiscal Service in 2024. I don't see institutional racism in an organisation which has judged to be institutionally racist. I don't see that as being something that an organisation ever says, job done, we're finished with that, we can move on to something else. It has to be something that you are seen to be constantly vigilant about, paying attention to, learning when you make mistakes and you miss things and you get things wrong, but learning for the best of reasons, which is that you remain committed to getting it right and getting closer to that state of full inclusion as referred to in the quote.
You say in your statement that your priority is to do all that you can to guard against the possibility that the quality of the service you provide will be impacted by the person's race, culture or language. In guarding against that possibility, do you continue to develop the sort of initiatives that you set out in paragraph 3, which we've already discussed, training, engagement and so on and so forth?
Yes, and we have a number of ways of doing that, and so we have a mechanism within the organisation to ensure that this issue is constantly being looked at. We bring together the people in the organisation who are engaged in this work, but we're also looking for gaps or new things that we could do, either in relation to learning from inquiries such as this, or looking at what other prosecution or death investigation services do. And an example of that is, after taking up my appointment, I came to the conclusion last year that there is a gap in our organisation, which is that we do not have data to tell us the impact of our decision-making on different communities within Scotland. And so we do not have data which tells us, I cannot answer the question because I do not have the data to tell me whether, for example, a black man is more likely to be prosecuted or not in Scotland. And that, to me, when I realised that last year from seeing some work that had been done elsewhere outside of Scotland, that was something that I then started a process to make sure that we could work towards filling that gap and developing that better understanding. So I think that continuous improvement, as you've referred to, is something that I think all of the leaders in the organisation understand, look for opportunities, and I think we are doing that.
The example that you just gave, can you tell us a little bit more about what you're doing to fill that gap where the data do not currently exist?
And unfortunately it's not an easy thing to fix because it depends on having data at scale in relation to the race or ethnicity of accused, but also having discussed it with other leaders in the organisation, not just accused, but we think we should also be able to answer these questions in relation to victims as well. And therefore, that data is not widely available, as I understand it, having started to look at this, either to the police or to the Procurator Fiscal Service. So that we have started some conversations to work out how we could do this, and that would mean some very significant changes. Now, an early indication is that with the implementation of the recent hate crime legislation, there may be a change on the part of policing, and I can't speak for them today, but I've been advised that there may have been a change on the part of policing in the last year or so in relation to the data which they collect in relation to either accused people or victims. And if that is correct and is of the right sort of data and at scale, then my hope is in the near to medium term we should be able to engage the sort of experts who can assess that data and tell us whether or not, or essentially tell us what the data shows.
Thank you. We're going to return to the theme of institutional racism, but at this juncture I'd like to ask you some questions about the Crown's approach to the precognition process following the death of Sheku Bayo. Now, do I understand correctly that you took a conscious decision not to watch any of the evidence led before the inquiry?
Yes, that's correct. I've not watched any of the evidence of any other witnesses.
That's helpful to know. What I can then do is read to you passages from the evidence before inviting your comment. Firstly, however, can we go back to the evidence that you gave in April of this year? You may recall at one stage you were read a passage from the statement of your colleague Les Brown, who was the solemn legal manager in the precognition process, in which he described an incremental approach being taken by the Crown to the precognition process. And he said, in essence, what we were doing here was trying to reach as quickly as possible a stage where Crown Counsel were able to exclude or otherwise criminality, and then allowed wider considerations to move forward in relation to issues that were considered relevant to a fatal accident inquiry. So you were read that passage from his statement and you were invited to comment, and what I'll do is simply refresh your memory by reading over to you the transcript of your evidence. You made it known to the inquiry that you had been unaware that this approach had been adopted in the circumstances of this particular case, and when asked to comment on the idea of an incremental approach, you said, what I would expect to happen is that an investigation would identify a number of issues which needed to be considered. And it was clear to all of us who were involved in those initial days that the question of criminality was an immediate or obvious issue which would need to be explored in the investigation, and in simple terms was an immediate priority. There may be wider issues which relate to broader learning which could come out of a fatal accident inquiry or an inquiry of this nature, but the priority would be to reach a decision on the criminal aspect as quickly as possible. I would not expect that would mean that those individual elements would be isolated off from each other and dealt with one at a time. The investigation would be trying to make progress on all of them at the same time as perhaps identifying particular priorities. I think our approach, as much as possible, is to progress the whole investigation. You wouldn't want a team looking at a criminal investigation and no one else dealing with the broader aspects that I've referred to until that team had finished. You would try to make sure there was sharing of information and progress on all aspects at the same time. So that's simply for the purposes of refreshing your memory as to the evidence that was put before you and the evidence that you gave back in April. Back in April, you were also asked questions by senior counsel in response to which you agreed, as all other Crown witnesses also did, that the Crown investigation required to meet the requirements of Article 2 of the ECHR, including the procedural obligations, which in turn include adequacy. And you further agreed that where Article 14 was also engaged, there was an additional duty imposed on state authorities to take all reasonable steps to unmask any racist motive and to establish whether or not ethnic hatred or prejudice may have played a role in events, and to pursue that investigation with vigour. So that's my summary of the evidence that's pertinent for today's purposes that you gave back in April. Finally, you were also asked by the Chair this question. In relation specifically to the issue of race, would you agree that in the circumstances of this case, the issue of race might have a bearing on the question of criminality? And you replied, I would agree that you could not consider the question of criminality without considering the question of race. The Chair then said, so to that end, would you be expecting CAPD to be investigating the issue of race as part of their exercise of investigating criminality? And you replied, insofar as it was relevant to the question that they were dealing with, yes, race was an issue that would need to be considered at the criminal stage. You were asked, you would have to look at race in order to ascertain whether there was any evidence that did have a bearing on criminality relating to race, and you agreed. And the Chair then said, and would you see that as part of a thorough investigation of the kind that you'd referred to earlier? Yes. And that a thorough investigation of that kind would in turn inspire confidence in the family? And you replied that would be the hope, yes. So I appreciate I've given you quite a lot of information. It's really just for the purposes of refreshing your memory of the aspects of your evidence in April that are perhaps germane to the questions that I want to ask you today, the themes I'd like to explore with you today. So against the background of your evidence, in particular your evidence in relation to Article 2 and 14 and your expectations of what CAPD would have been looking at as part of the precognition process, and in particular their exercise of investigating criminality, I'd like to share some evidence with you now as to the approach that was in fact taken by those tasked with carrying out the precognition. And I do so because I appreciate that you haven't watched any of the evidence. So again, I'd like to give you quite a lot of information before inviting any comment. Fiona Carnan was the fiscal depute who was tasked with drafting the analysis, and she was asked about the approach that she took to race. And she said that essentially it was a two-stage process, that she was looking for evidence of criminality, and if and only if she found evidence of criminality, would she then go looking for evidence of a racial aggravation or motivation for that criminality. And in a statement that she produced to the inquiry, she said this: if my analysis of evidence had established that there was sufficient evidence to support criminal charges against any of the officers, the question of any racial motivation or intention would have been addressed at that stage. Since the analysis of evidence did not identify criminality by any officer, the question of racial aggravation did not arise, since no offence had been identified. So that was the approach that she took. I then asked her whether she'd taken certain matters that may have a bearing on race or racial motivation into account, given the approach that she had outlined to us, and also given the absence of any express analysis in relation to race within the analysis chapter of the Precognition. So she was reminded that there was evidence available to her at the time that she drafted the analysis, that some officers were concerned they were attending a terrorist incident. First on the scene in particular were Walker and Payton. Constable Walker said, "It did cross my mind he was doing this to get the police there, bearing in mind we're on a severe threat level for an attack on the police." And former Constable Payton said, "It also ran through my mind that this male could be part of a terrorist plot." And later, in the statement he produced, he said, "I kept thinking about the Lee Rigby boy, the soldier who was killed." So Ms. Carnan was reminded of what Constables Walker and Payton had said in their statements. And then she was asked, as part of the process you went through in your analysis and in ensuring Article 2 and 14 compliance, did you consider why the possibility of terrorism crossed their minds? And she replied, "I asked the question, although I think it had already been answered, why they had why they had considered terrorism, because they had a briefing, 2 briefings in the early month of 2015. She was asked, "Did you consider whether they would have thought about terrorism if Mr. Bayo had been white?" No. "Did you consider whether they thought about terrorism every time they went to a knife call?" No. "And did you consider why Constable Payton thought about Lee Rigby in particular?" "I simply noted his position." "You didn't give thought as to why he thought about Lee Rigby?" "I didn't interpret it as being influenced by race." No. "Did you consider whether Constable Payton would have been thinking about Lee Rigby if Sheku Bayo had been white?" "I didn't ask that question." "Did you consider whether there was evidence from which the inference could be drawn that the colour of Mr. Bayo's skin was relevant to their concern that the incident was related to terrorism?" "I did not make that assessment." She told us in her evidence that she made no reference to the use of racial tropes or negative stereotypes used by the response officers in their statements, because the use of racial tropes is not criminal, and evidence about negative attitudes would not be relevant to the analysis unless criminality was identified. In her evidence, I said to her, "You'll be aware of racist stereotypes in society, that black men are more violent, unpredictable, aggressive. You'll have come across these, I would imagine." She said, "I have." I asked her, "Did you examine the officers' statements for language of that sort?" No. "Did you consider patterns of behaviour for whether, for example, they'd used their sprays or drawn their batons at previous knife incidents?" No. Did you consider whether they treated all knife calls as potentially terrorist-related? No. Did you consider looking for comparator evidence? For example, looking at a history of use of sprays or use of force involving a baton, whether the officers had used sprays or batons before? No. Or whether they'd used sprays or batons when detaining a white suspect? No. She was asked questions around the speed of the incident. Did she consider whether the speed with which the officers elected to use force was because he was black? She said, that wasn't my understanding. I think I've explained my understanding of their perception was based on a whole lot more than the colour of his skin. Did you consider whether Constables Walker and Payton opted for a hard stop may have been influenced by race? And she replied again, we didn't cross the threshold into criminality, so that wasn't a consideration per se. So Ms. Carnan was candid in her evidence that these questions were simply not asked by her as part of her process of analysis. Now, Stephen McGowan was taken through these chapters of evidence in his own evidence, and his comment was invited, and he said, these are all relevant questions. The same exercise was carried out with Lindsay Miller, and she agreed these were all relevant questions. Would you also agree with that? Is there anything that you would disagree with there?
There's quite a lot there, but no. From what you've read out, no, I don't. There's nothing there I would disagree with.
Stephen McGowan was asked, with hindsight, did the Crown investigation take all reasonable steps to unmask any racist motive? And he replied, I think there are further steps that could have been taken. Lindsay Miller was asked the same question. She replied, on the basis of Ms. Carnan's evidence, no. Would you agree with their sentiments?
It's very difficult for me to answer that question because, as I think I said on the last occasion, I wasn't involved in the investigation, and in preparing to give evidence on the last occasion and today, I wasn't asked or directed to that issue in this way, and therefore I neither have personal knowledge nor have carried out any research in relation to the case, which allows me to form a personal view on the appropriateness of the level of investigation. But from listening to the factors that you've read out to me, as best as I can remember them, it appears to me that the Crown was carrying out 2 investigations. And I think it's always important to remember that in some cases like this, there are 2 investigations. And sometimes in our past, it has been the practice essentially for the same person to carry out both investigations at the same time. At this time, because we had developed specialisms, my understanding, and it is only my understanding, is that, because I wasn't personally involved, is that different aspects of each investigation were being carried out by different people and not in parallel. They were in sequence, and that's one of the things that we've changed since the investigation. I've given quite a lot of thought to this, to the extent that it was raised with me on the last occasion, because it seems to me from the text that you've read out that Fiona Carnan was being asked about her consideration. As I understand it, she was part of the investigation considering criminality on the part of the individuals or the police force. And she was being asked about her consideration of race as part of that. And it has led me to wonder whether that separation and specialisation is really what is at the root of the way in which those questions were being answered. And that what it has exposed is whether or not, in the context of a criminal investigation, some of the factors which might be, for example, might not be admissible evidence in any criminal matter, but may be relevant to the broader questions you've highlighted, and would therefore be considered by a death investigation leading to either a fatal accident inquiry or an inquiry like this. That approach to separation and specialisation did not help us here, because these are all things that, in my view, should have been considered. not least because of, in addition to the question of the evidential value they might have, it also becomes an important factor in building the confidence of the nearest relatives that we ourselves, in the way that we approach our work, understand issues of race, and that we understand the importance of the broader question of establishing what happened. And so it's, if I can bring that back to your original question, and I make apologies for my lengthy answer, but I think it is difficult for me, without personal knowledge or research of the case itself, to give you an answer today, which is to say whether I regard the investigation as satisfactory or not. I don't think I can do that. But I think what I can say is that there were factors in the way that this investigation was set up and established that may have led one part of the investigation not to consider a broader range of information that may have been thought relevant to a separate investigation. And I use separate in that sense of the way in which we were structured at the time.
Thank you. There's no need to apologise. I think your response was shorter perhaps than the question that I asked. You referred to there being two investigations and to them being separated out. That's the investigation in relation to criminality and the broader investigation around death. And I think you said that perhaps they were being considered by different people. The evidence that we have heard is that there were not two parallel inquiries running here. There was simply the investigation into criminality, which culminated, as far as the Precognition process is concerned, in Fiona Carnan's preparation or drafting of the analysis. And the idea, as I understand it, and I will be corrected if I have misunderstood the evidence, was that after a decision had been taken on criminality, and in the event that the Crown were to turn their minds to whether there should be a fatal accident inquiry and to begin to prepare for any such inquiry, these broader issues would be considered at that stage. They were not being considered in parallel. It was very much a sequential process. Now, nothing may turn on that, but I wondered if perhaps we were at slightly different or slightly cross purposes.
No, I can assure you we weren't. I didn't mean to give the impression that I thought there were parallel investigations. My understanding from the way the questions were asked of my previous attendance at the inquiry is that there was a criminal investigation, and then there was going to be a consideration of whether or not there should be, in the traditional way, a fatal accident inquiry or something broader and deeper, such as this inquiry. Now, so I don't think for a moment that there was a parallel set of investigations here, and that also fits with my experience of the time that came about as a consequence of us having established specialist teams that where an incident gave rise to both a criminal investigation and the need to consider the consequences of the deaths, we did, I think, adopt a process of, perhaps understandably, trying to conclude the criminal investigation as quickly as possible, but that perhaps was done to the exclusion of the wider investigation. And I think that's one of the things that we have changed and learned since 2015. We now don't adopt that linear approach. We very much try to replicate the benefits that I think I spoke about on the last occasion of the traditional approach, where the local Procurator Fiscal would carry out all aspects of the investigation. And therefore, I think we've tried to recreate that, but still maintain the benefit of having specialist teams. Now, the difficulty that I've thought about since giving evidence on the last occasion is this question of race that I was being asked about and the extent it should be considered in the criminal investigation. And that has made me think of, in the context of a criminal investigation, our prosecutorial approach to race has very much been driven, I think, by the need to prioritise and tackle hate crime. And those are cases in which there is very often obvious evidence of racial hatred, either before the incident or after the incident or during the incident. And that evidence is admissible, and therefore the prosecutor can put it before the court and seek a conviction for hate crime under one of the legislative mechanisms that exists. What I have begun to think about, I think, since giving evidence on the last occasion is that a death investigation without any criminal investigation may have available to it evidence which doesn't fit that category that I've just described, that we are more traditionally used to as prosecutors. And that is, I think, the sort of factors that you were highlighting that were put to Fiona Carnan. And the question that was put to me on the previous occasion was really the extent to which we should use and rely on that information as part of the criminal investigation. And I still maintain, I think, my answer from the previous occasion, that the prosecutor should be looking at that. There are two reasons for that. One is, it is important to build an understanding as to whether or not, in the absence of any of the explicit evidence of racism, whether that information provides a basis for the prosecutor to seek a conviction which has an element of hate crime to it. The second element is the one I've already referred to, which is it's important to demonstrate to the victims or the nearest relatives in a death case that we are not, that we understand those issues and we've taken account of them. But the difficulty is that type of evidence and information that you're referring to doesn't neatly fit in the criminal context into being admissible, relevant evidence for a criminal offence. And I suspect that is the heart of the issue that was ultimately being explored with Fiona Carnan. And to my knowledge, that question in Scotland is unexplored in a criminal trial, the extent to which prosecutors could bring before the court the type of information that you're talking about and rely on it to seek a conviction. But that doesn't mean it shouldn't be considered for the reasons that I've talked about. And I think that's, to my mind, the importance of considering it.
Thank you. That was a very full and detailed answer.
I'm sorry.
Please don't apologise. It's a very helpful answer. But if I may, I'll ask some follow-up questions in relation to that answer. You gave evidence back in April, and I reminded you of it this morning, that one cannot consider criminality without also giving consideration to race. And you've given evidence that the sort of matters that Fiona Carnan told us she didn't consider, the sort of questions that she didn't ask herself, were all matters that, in your view, ought to have been considered as part of the process of considering criminality, and not parked until such time as consideration might have been given to preparation for an FAI. And you put forward two reasons for that. First, around building an understanding of whether, even absent explicit, overt examples of racism, slurs, things of that sort, there might be a basis to invite the court to convict of one or other of the hate crimes. And the second reason being it inspires the confidence of the family and the approach that the Crown are taking, and I suppose the confidence of the public more broadly.
Yes.
You said too that there may be issues around admissibility and relevancy. We were looking primarily at things said by officers in their statements, and we did have evidence from the allocated Advocate Depute, Ashley Edwards KC, that she was of the view that the statements would pass the test for admissibility. She took us to a case called Johnson and said that that was her assessment, that these statements would be admitted in evidence, and that she would always take the Crown case at its highest. So that may or may not have been an issue, but regardless of whether there were concerns around admissibility and relevancy, I hear you say that these were matters that should have been considered as part of the process. And are these matters that you would then have expected not only to be considered in the precognoser's or the analyst's head, but set out in the analysis of the evidence to demonstrate that they had been considered, irrespective of the conclusion reached by the analyst following upon that consideration?
Yes, in my experience, all aspects of the case preparation that are considered in that way should be set out in writing, because that is how you reach a well-informed decision for the decision maker at a subsequent stage, because you're describing a process which you and others, but not everyone, might understand that the precognoser is not the decision maker. The precognoser is the investigator, and it's their job to gather the evidence, to analyse it, and make recommendations. So, in my view, there would be little value in considering something but not recording the different factors that you had looked at, the balancing that you had performed, and the conclusion that you had come to. And you do that in order to assist the person who then takes the decision, in the knowledge that they may disagree with you, but they can only do that effectively if they've had access to your thinking on the matter.
Now, ultimately, it will be for the chair to the inquiry to determine whether the precognition process was compliant with Articles 2 and 14. But there is at least a possibility that the chair may take the view that the Crown's approach to race was inadequate. If the chair were to take that view, I would be interested in your comments on this matter. In relation to Fiona Carnan, who was candid in her evidence that she simply didn't ask herself any of the questions around use of language, patterns of behaviour, comparators, and so on. Would you see those failings, if they are deemed by the chair to be failings, to be personal failings or institutional ones? Possibly both?
I would regard them as institutional failings, not personal failings. And I say that because the individual was working within a system that had been established by the organisation. And given the factors that I've described in my analysis and my thinking of this since April, I think what was being described to the inquiry was something that arises from the way in which the Crown was structured to focus on specialism, and therefore it wasn't something about the individual's approach to it. And if there are other factors which led to it, such as a lack of clarity or a lack of guidance on understanding the importance of race, then those would be institutional as well, rather than personal. So I would regard it as an institutional matter.
And what about the solemn legal manager who ultimately countersigned the precognition and didn't identify these failings, if indeed they are failings? Would you see the solemn legal manager's endorsement of that precognition as of what might be thought to be an inadequate precognition, or might be concluded to be an inadequate precognition? Would you see the solemn legal manager's failing in that regard as a personal one or an institutional one?
So again, I have to stress that I wasn't directed to this issue in either of the statement requests, but I think my answer to that would be the same as in the previous. If it's institutional for one person who is part of a case, then those factors are relevant, I think, for others. But I think it's important to say that the factors that we're talking about here were not, as I understand it, factors which were ignored altogether and not considered relevant. Having concluded the criminal investigation, my understanding is that the organisation then, not in parallel, but then turned its mind to what the appropriate outcome of the death investigation should be. Now, I stand to be corrected, but my understanding is that the organisation came to the conclusion, ultimately it would be a decision of Crown Counsel, that a fatal accident inquiry would not be adequate in this case. And the reason would be that a fatal accident inquiry would have too narrow a perspective. And it was therefore the Crown's assessment that an inquiry of this nature was required, and therefore the Crown's analysis in many ways led to the establishment of this inquiry by, as I understand it, the Lord Advocate making representations to Scottish ministers that the death investigation could not be satisfactorily concluded by a fatal accident inquiry. And I think that my perspective, having thought about these issues that you've highlighted since April, is that they must have been part of that thinking, because what you're highlighting are very relevant factors into the consideration of Mr. Bayou's death. But there was a need for them to be properly explored in detail in a way which could look at the sort of issues that you're describing.
Again, I stand to be corrected if I am wrong or mistaken in what I'm about to say, but my understanding is that the inquiry has not heard any evidence of any further consideration being given to these issues, or any further analysis of their potential import between the decision that no proceedings should be taken against the attending officers and this inquiry being constituted. I will be corrected if I'm wrong, but that's my recollection of the evidence before the inquiry to date, that those matters have not been revisited.
So to help the inquiry, I think there are two factors that are relevant there. One is I'm basing my comments today on the way in which the information was put to me. I think on the previous occasion that it was described by colleagues as being sequential, and it was not for one stage of the inquiry, but it would be for the next. But the second factor is also that the Crown's criminal investigation did not just cease and then Scottish ministers established a public inquiry. That was not, as I understand it, what happened. Now, I have to preface that by saying I wasn't involved in those discussions, but my understanding is the Lord Advocate at the time, on the conclusion of the criminal investigation, then had to give very, very careful consideration as to what the next step should be. And one of those options would have been a fatal accident inquiry. And that was judged to be inadequate because of the limitations in the legislation and how a fatal accident inquiry works. And therefore, my personal view is the Lord Advocate judged it to be appropriate that there should be a broader inquiry, and made those representations to Scottish ministers. That, it seems to me, must have been based on a broader analysis than would have been provided for Crown Counsel in the criminal case. Any consideration which I've ever been involved in relation to a death investigation doesn't just look at the evidence that's relevant for criminality, but looks at a broader range of circumstances.
Well, no doubt the inquiry, if it deems it necessary and helpful, can explore why the Crown took that position, and to what extent the issues that we've been exploring in our evidence today around language, comparator evidence, patterns of behaviour and so on were relevant to that consideration.
And I should be very clear, I'm not saying that I have personal knowledge that they were, but it seems to me from the way they were described in the previous occasion that that may have been the intention of what Fiona Carnan was trying to describe.
Thank you. But returning for present purposes to the consideration of the criminal aspects, and the possibility that a view may be taken that the precognition process, that is the precognition process that explored the possibility of criminality on the part of the attending officers, was inadequate. We have talked about Ms Carnan, the analyst, and your view is that any failings on her part would have been institutional rather than personal, and you hold the same opinion in relation to the solemn legal manager. I wonder if we can consider briefly the position of the allocated advocate depute, Ms Edwards KC. She was asked, when you said here race didn't really feature in the examination of the actual restraint, you were focusing on the actions. And she replied, yes, the actus reus as opposed to the mens rea. She was asked, right, so did race feature in the examination of the mens rea, the state of mind? This is in terms of her own analysis. And I should say, before I say anything further, Mr Logue, that the inquiry cannot probe the actual decision taken by a Crown Counsel, and I cannot ask any questions around that. Ms Edwards replied, it did, and you've asked me that already, and I've said absolutely. So the question that I'm asking in my head, why did that officer do that? Why did he do that at that particular time? What I needed to be clear in my own mind, first of all, was what was that? What was the factual matrix? So once we had that, and there might have been points where we just couldn't say this happened or that didn't happen, but that's what we were trying to get through the investigation of the actual facts. What could we say were the elements of the actual restraint? And once that was in place, I could ask the question, why did that happen? Why did that officer do that? Why did that take place then? Why was something else not done? Was that reasonable? She was then asked, and in terms of this, you said it was going on, the thought process was going on in your head. Yes. Was there any analysis that we could look at on paper where we could follow that rationale, that process? You have said that you were asking yourself, why did the police officer do that? Was that reasonable? And she replied, so the thing that ultimately came to help me with that, when I'm looking at a case, I'm reconstructing in my head, I'm asking questions, and if there's a gap where I don't know where the answer is, it's either because I'm not understanding what's being told to me or I simply don't have that information. That's when I look around and say, okay, I need further help or information on that, or I need an expert to help me. So that was her evidence. If I might read that short, it appears that she was saying that she took race into account when looking at the case, and in particular in her analysis of mens rea, but there was no evidence that this was a matter that was committed to paper in any sense. And again, if the chair, working on the hypothesis that the chair may take the view that process, that approach was inadequate, would you see that failing as being an individual one or an institutional one?
I'm sorry, can you be clearer about the nature of the failure that you're describing?
Well, the evidence that she gave was that she did take race into account in considering mens rea, but her thought process does not appear to have been committed to paper. I suppose that may raise an issue for the chair as to the extent to which he can be satisfied those matters were in fact taken into account. I think you said yourself in evidence there's little value in considering a matter but not recording the factors that you looked at and the conclusions that you came to. If the chair were to take the view, particularly in the absence of any form of audit trail here, that her analysis of race again was inadequate, and so to the extent that she failed to take into account to the degree that might have been expected the matters that were put to Ms. Carnan, which we've discussed this morning, would you see that as being an individual failing or an institutional one?
I think I would need to know more about the circumstances of the decision making and how it was done. Was it done by it's difficult to say without knowing more about the way in which the decision was done. Sometimes these decisions can be informed by very detailed discussion by all of the people who've worked on the case. Sometimes they're taken by individuals who base their decision just on the written material. It's very difficult to say on this specific example without being involved or knowing more about it.
I appreciate that, and I regret I can't help you further with that because the inquiry can't probe the decisions. The information that I provided to you is really the extent of the evidence that Ms. Edwards was permitted to give on that subject. Perhaps finally, and for completeness, we should also consider the position of the Lord Advocate here. We've heard evidence from both Ms. Edwards and James Wolfe, KC, that the process that was adopted here was that Ms. Edwards prepared Crown Counsel's instructions in draft, which were sent to the Lord Advocate effectively for approval by him. And Mr. Wolfe gave evidence that he had a meeting with Crown Counsel at which her draft Crown Counsel instructions were discussed. And he was asked, do you remember preparing for this meeting with Crown Counsel and considering the papers that you had available, did you notice that there was an absence of analysis in relation to race? Was that something that you were alert to, alive to, when you read the material? And he replied, well, I mean, I was certainly alert to the background of race. I mean, I cannot now remember. Well, I think perhaps I could go as far as to say I would be surprised if I didn't ask her about her thinking in relation to the question of whether race played into the question of criminality, but it would be not fair either to her or to anybody else to put it higher than that. And, you know, she may have a recollection that I don't have. I think I would be surprised and disappointed in myself, if I can put it that way, if I didn't ask her questions about that aspect of the case, because it was clearly a core question. Now, with the caveat that the inquiry cannot probe the decision taken in this case and therefore has not seen Crown Counsel's instruction, Mr Wolfe doesn't appear to have a clear recollection of a discussion around race. And again, the inquiry does not have before it any paper trail, any minutes from this meeting, anything that would allow the inquiry to be satisfied that the issue of race was explored and discussed between Crown Counsel and the Lord Advocate. In the absence of any paper trail, it would be open to the chair to give consideration to the extent to which such a conversation took place. And if the chair were perhaps to conclude that the matter of race was not explored or was not explored adequately as between Crown Counsel and the Lord Advocate, then again, can I invite your views as to whether you would see that as a personal failing on the part of the Lord Advocate or an institutional one?
I'm afraid my answer to that is very similar to the last one. I wasn't part of the discussion, and I don't think I can properly and fairly help the inquiry by offering a view as to whether I think that would be a fair or proper criticism of the way in which the decision was taken.
That's very fair, thank you. Can we, just before we conclude, we ordinarily take a break at around about 11:30, perhaps return to paragraph 2 of your statement. In paragraph 2, here we are, you set out Lord Macpherson's definition of institutional racism, the collective failure of an organisation to provide an appropriate and professional service to people because of their colour, culture or ethnic origin. It can be seen or detected in processes, attitudes and behaviour which amount to discrimination through unwitting prejudice, ignorance, thoughtlessness and racist stereotyping which disadvantage minority ethnic people. Now, perhaps leaving to one side Crown Counsel and the Lord Advocate, because I appreciate the limitations of the information before the inquiry upon which I can ask you to express any view, but focusing perhaps on the failures or potential failures of the analyst and the solemn legal manager. If the chair were to take the view that the precognition process was inadequate, insofar as it didn't consider or did not adequately consider the question of race, do you have a view as to how those failings might measure up when read against the definition of institutional racism?
Well, both of those aspects, I think, would fall to be treated as failures in processes, I think, from the way that we've described them. And I think your question is if the inquiry determines that I think your question is if the inquiry determines that amounts to institutional racism?
No, sorry. If the inquiry were to take the view, if the chair to the inquiry were to take the view that the precognition process was not adequate as required by Articles 2 and 14 of the Convention, insofar as it did not properly consider race or a racial motivation, then when we look at that failing against the definition of institutional racism, I'm wondering whether we might find ourselves in the territory of not only an institutional failing, but institutional racism.
It's a very difficult question. It's a very difficult question to answer. And I say that not because, I say that because, as I mentioned earlier, I wasn't party to the broader consideration that followed after the conclusion of the criminal investigation. And I think I would really need to know more about that part of the Crown's duties really to be able to provide a definitive answer to the question that you're asking. But what I can say is this, that there is no doubt that the factors that I think led to those failings that you're describing, I think, are factors that have been recognised, and I think some work has been done and more work still needs to be done to ensure that those institutional elements that I've accepted do not reoccur. But I would think it's a very fair question for the inquiry to consider in terms of this definition and the question of process, the extent and impact of the failures that you've described.
Thank you. Can you bear with me a moment, please? I'm conscious, sir, that I'm
We'll
slightly
take a
overrun.
20-minute break at this point. Ms. Thompson.
Thank you. Mr. Logue, I'd like to move on to ask you some questions now about training and guidance. And perhaps an easy way into this would be to read you a short chapter from Lindsay Miller's evidence. I asked her, had guidance been published within Crown Office as to how to recognise racial bias in an investigation of this sort? And we're concerned with the period during which this precognition was undertaken, so roughly 2015 to 2018. And she replied, there's certainly considerable guidance in relation to the investigation of racially motivated crime and the use of the then racial aggravations when preparing cases for prosecution. And I said to her, we've looked at what was Chapter 44 of the Precognoser's Handbook, which deals with Section 50A and Section 96, the racial motivation for racial aggravations. So that chapter of the handbook certainly deals with the nuts and bolts of how to approach those two sections, and it explored what the threshold was for each. But in terms of where to look for evidence of racial bias, how to approach that task, was there any published guidance? And she replied, I'm not sure that there is. I might be wrong about that, but I'm not sure that there is on that specific issue. And I said, okay, do you think that's something that might be helpful? And she said, yes. Can you add anything to the evidence she has already given? To the best of your knowledge, was there 2015, 2018, and indeed is there now, any guidance within Crown Office as to how to recognise racial bias in an investigation of this type?
I think you're identifying a gap there in our guidance. And again, this is something I've thought about since I last gave evidence, and which relates to the broader understanding of how in an investigation, whether that's a criminal or a death investigation, to identify these broader factors that you're describing. And I think what would have to go with that guidance would be an addition to our training on the factors that you've identified, such as the use of language and such like, in the context of an investigation.
Can I ask you to have a look at some guidelines that have been prepared by the PERC? If we can bring these up on the screen, please. They're PERC 04724. Now, Michelle MacLeod, who is the Commissioner, gave evidence last week, and she approved these guidelines and had a hand in the drafting of these guidelines. They were published in November of 2021, but they are based on or are an adaptation of guidelines issued by the IOPC back in 2015. So we see on the first page here, PERC guidelines for dealing with allegations of discrimination when undertaking investigations and complaint handling reviews. Have you seen these before?
No, I haven't. No.
All right. What I'd like to do is take you on a whistle-stop tour through these guidelines, just so that you have a sense of what they contain, and then simply invite your comment as to whether it might be helpful for the Crown Office to consider introducing something similar. So I wonder if we can begin. We can skip through the preliminaries and turn to page 6, please, which is headed up, What is Discrimination? And we can read this short, but this chapter begins by looking at the Equality Act, which defines unlawful discrimination and prohibits discrimination relating to the protected characteristics, which are then listed, and they include, of course, both race and religion. If we scroll to the bottom of the page, this is relevant perhaps more in context of policing, but there's a reference to the standards of professional behaviour required of police constables to the effect that they must not discriminate unfairly. And then building on that framework on the next page, that's page 7, there is a heading Discrimination and Human Rights and a paragraph or two on Article 14. Article 14 of the ECHR also provides protection from discrimination. This protection only applies where it is alleged that discrimination has affected a person's ability to enjoy one or more of the other human rights set out in the Convention. For example, Article 14 would apply if an allegation was made that discriminatory actions led to a death in custody, as a death in custody would engage Article 2. And for the purposes of Article 14, discrimination is where a person is treated less favourably than another person in a similar situation, and the treatment cannot be objectively and reasonably justified. So this chapter gives the framework around discrimination, the Equality Act, Article 14, and there's a reference to the standards of professional behaviour that apply in policing. If we move to the bottom of that page, there's a section headed Tests for Discrimination, and a definition is given of direct discrimination as being when someone is treated less favourably than another person because of a protected characteristic or characteristics. And if we scroll to the top of page 8, please. It is said that less favourable treatment suggests a comparison less favourable than who. The who is a person in the same situation who does not have the same protected characteristic. For example, you might compare the treatment of a black person to how a white person would have been treated in the same circumstances. Making this comparison is a key part of the investigation or review. And there's a little text box further down that says, in determining whether there has been direct discrimination, the question to ask is, would the person be treated in this way but for their protected characteristic? If we could perhaps scroll now to page 16. Where there's a heading, Understanding the Allegation of Discrimination. Discrimination can be overt and expressed as open hostility or use of offensive, degrading language. However, it is more than just these things. Direct discrimination includes actions that are informed by biased assumptions or prejudice in respect of a protected characteristic, even if this is done unconsciously. And its focus is brought in the next paragraph to the need for an investigating officer to have an understanding of what discriminatory assumptions might be. And if we can just look in passing at the various headings on this page, the investigating officer should consider what does the complainer say and take time to understand why the complainer feels they've been discriminated against. And I skipped over an earlier passage, Mr. Logue, that made clear that in the context of a death, we simply substitute next of kin for complainer. There is then a heading, what do you know? Are there any stereotypes or common assumptions made about the protected characteristic group that you're aware of, which might be relevant to consider? Ms. MacLeod, in her evidence last week, said that the PERC recognise that they perhaps should not assume that all of their investigating officers will have a good working knowledge of racial stereotypes around discrimination. Our focus, of course, was on race, and I understand that these guidelines are either being reviewed or expanded upon or supplemented in some way, and that a list of illustrations is to be provided to ensure that it's not taken for granted that investigators will recognise stereotypes when they come across them. There is then a heading, what do you need to find out? And the suggestion is made that in more serious cases it may be appropriate to seek external expertise, for example from an advisory group, a community advocacy organisation, or from a legal or academic expert. If we carry on a little bit further, there's a heading, racism. In the context of complaints of race discrimination, it includes any discrimination relating to race, ethnicity, or nationality. And an example is worked up involving a black man. Let's read it short. It concerns a 19-year-old Asian man, I beg your pardon, who suffers from Asperger's syndrome and autism, who says that he was arrested by police and questioned about why he had come to the UK from Pakistan and was assaulted when he was arrested. And he considers that the questioning was motivated by racism and that his conditions meant he was unable to effectively engage with the police. And then the example works through how such an allegation might be handled by an investigator. And we see that the investigator should ask themselves what types of assumptions, prejudices or bias might lead to an Asian man with Asperger's syndrome and autism being treated differently due to his race and resulting in the use of excessive force. Would a white man with similar issues acting in the same way be treated by these officers in the same way? And if we move on to the next page, I'm just picking out the parts of this example that appear to be pertinent here. So drawing on background information and the details of the discrimination allegation provided, the investigating officer identifies questions to be addressed through the investigation, and these include: were the officers aware, or could they have been reasonably expected to be aware, that Mr. A had difficulty engaging because of his conditions? What assessments were made to take account of his conditions? How was this reflected in the actions taken? In light of his challenges, was it appropriate for him to be arrested and taken to a cell? And again, the comparative question: would a white man with similar challenges have been arrested in these circumstances? Were assumptions made that his behaviour was a result of drug-taking, aggression or criminality, rather than symptoms of Asperger's syndrome and autism and a reflection of vulnerability? Would similar assumptions have been made if he was white? And is there any indication that the officers involved hold negative views of Asian people, or that he was targeted because of his race? So these are the sorts of questions that an investigator should look to answer through the course of the investigation. If we could turn to page 32, which is a section headed Conducting the Investigation. This section highlights that the importance of the understanding acquired at the beginning of the investigation and how this will inform key lines of inquiry. And reading short the text that we see on the page here, it stresses the importance of looking not only at the lines of inquiry that you would expect to be followed in any case involving statements, CCTV, and so on and so forth, but to take cognizance of the fact that in discrimination cases there may be little or no direct evidence to support an allegation, particularly the case if the allegation is about discriminatory actions arising from prejudice, assumptions or attitudes. And so the investigation will need to consider whether there is other evidence which supports the allegation of discrimination. And this might include looking at the officer's complaints history, patterns of behaviour. I think we can read this short, and over the page on page 33 there's also a suggestion that comparator evidence should also be considered. This will involve comparing how the complainer was treated against a person in the same situation who doesn't have the same protected characteristic. And finally on page 34 there's a section headed Discriminatory Language. As part of the consideration, the investigator should assess the language used, including language used in any records relating to the incident in question or arising from the complaint investigation. This includes any use of obviously discriminatory language, but also more subtle indicators that a person may have acted or made a decision based on prejudicial assumptions. There are terms that are commonly recognised as being offensive, and officers and police staff members should be expected not to use them. However, there are other words and phrases which are inoffensive in themselves, but, when heard in context, can reasonably be thought of as being discriminatory. So that was a very quick run through the guidelines, but hopefully will have given you a flavour of the guidelines that have been in force within the PERC since 2021. And I'm interested to know simply whether you feel that guidelines of this type, not identical guidelines, but guidelines of this sort, might help to correct the gap that we have identified in your current training and guidance provision within Crown Office.
I do, but I think if I could make a couple of points just to put it in context. One is that the early part of the guide, which you showed me, which I would describe as having very general material, I think is well available to colleagues in the Procurator Fiscal Service in what I would describe as our more general guidance and training material in relation to equalities. The more specific parts of the guidance, the later part of the documents, I think we have begun to take steps to develop and implement guidance of that nature, but I would not describe it as complete. So, for example, I think I said on the last occasion I gave evidence that there was specific guidance focused on Article 2, but also Article 14, I think, in relation to some of the more specialist teams that now investigate categories of death. So, for example, we've established since 2015 a team which deals with deaths in custody, and they have, if I remember correctly, it was back in April I last looked, they have specific guidance in relation to deaths, which deals with the issues through the question of the convention articles. What I think is helpful in this guidance that I don't think we have enough emphasis on is the broader look at, for example, I think it's described as being language which may give an indication, the less overt language and the language which gives rise to considerations of assumptions that may be discriminatory as such. I think I see in this guidance quite a helpful way of linking that to the investigative role. And I think in the past, I think we've perhaps relied too much on it being available as a general source of guidance for all aspects of our work and not focused it in this way on the investigative and prosecution functions which we perform.
Thank you. I didn't mean to suggest that you might import these guidelines wholesale. I simply wonder whether guidelines of this sort might potentially inform or inspire bespoke guidance within Crown Office.
As I say, I think we've started that process. I think these guidelines, as always, when you do something like this, you learn from others that have gone ahead of you, and you develop your own features, and I think there is something here for us to do in that area.
Thank you. I would like to move on to another topic now and ask you some questions concerning the murder of a man called Simon San. Now, to get our bearings, I'm going to ask you to look firstly at a review of the way that the police investigated his murder. But the end point is going to be that I will take you to a Crown Office press release that has your name on it. And I'm particularly interested in asking a question or two around your knowledge of the press release and the Crown Office position as set out in that press release. But I wonder if we can begin, largely for the benefit of the public listening to this case, by getting our bearings, by going to the Operation Wymark Executive Report. This is PS 18902. And we see this was, well, it's now the Legacy Force, Lothian and Borders Police, Operation Waymark, an inquiry into the questions and complaints raised by the San families. This was an internal investigation carried out by Lothian and Borders Police. And on page 3, there is a little background about the case that will set the scene. We're told here that on the 11th of August 2010, Simon San, a 40-year-old male of Chinese origin, was attacked and assaulted by a group of youths in the street in Loch End, Edinburgh. He died the following morning from the injuries he sustained. In paragraph 1.2, it is explained that he was employed as a delivery driver at his sister's takeaway premises close to the place of the attack. At paragraph 1.4, on the evening in question, he was working for his sister, delivering food from her shop, and at about 10 o'clock at night, after making a delivery, he returned to the shop and parked his car on the road near to the premises. At 1.5, prior to alighting from his vehicle, a group of youths, males and females, approached Simon's motor car and started to rock it. As Simon exited the vehicle and telephoned 999, he was attacked and punched, causing him to fall to the ground and strike his head, rendering him unconscious. His mobile telephone and car keys were subsequently stolen. At 1.6, we're told that the emergency services arrived. He was taken to hospital by ambulance but did not recover consciousness, and life was pronounced extinct on the morning of the 12th of August. At 1.7, Lothian Borders Police instigated a major investigation, Operation Millennium, into the attack. 4 males between the ages of 14 and 16 were arrested and reported to the Fiscal, and one accused, John Reid, pled guilty to culpable homicide less than 2 months after the death of Simon San. So that is the background. If we might turn to page 4 now, please. Allegations made by the family at 3.1, it is said that 39 allegations, all non-criminal, and 11 questions were identified from the initial statement noted from the family. For the purposes of the report, they were summarised into areas of concern, And I simply wish to note here the third bullet point, the concern raised by the family of a failure by Lothian Borders Police to recognise that the attack on Simon was racist, and denial that this was a motive at an early stage. If we can turn to page 7. This is the outcome of the investigation in this regard. 6.1, racist motivation. The police failings on this specific element throughout the investigation into the attack on Simon have been one of the key sources of distress, frustration and anger for the family. And it is said that the first question asked is why the police are not taking account of the family's perception that this is a racist incident. And this was a letter written 12 days after the death. 6.2, the Stephen Lawrence Inquiry Report defines a racist incident as being any incident which is perceived to be racist by the victim or any other person. This definition was adopted by the police service in Scotland and guidance for officers had been issued. And at 6.4, the complaint inquiry concluded that Lothian Borders Police failed to recognise that the attack on Simon was racist. This was not only at the outset of the investigation but also as it progressed. Key elements that contributed to the collective failing included, and the first bullet point there is a misguided assessment that the motive for the attack was robbery, and towards the bottom of the list, little emphasis placed on racist language used by the accused shortly after they attacked Simon, and not establishing the perception of the family. And if we might look at page 11, please. These are the findings in relation to language that had been used by the accused. The Operation Millennium investigation team placed little emphasis on racist language used by the accused shortly after they attacked Simon. Although several members of the investigation team claim to have read the statements, they state that the statements contained no or only limited evidence or information to suggest the crime was racially motivated. Information from witnesses shows that a short time after the attack on Simon, the group responsible were directly referring to him as, and there's a racial term there, it is crucial to highlight that the group are talking directly about their attack on Simon, and the references are made in the presence of independent witnesses. The 4 accused were very quickly identified and all were subsequently traced, interviewed and arrested. An interview strategy was prepared and applied during the interview of each accused. This strategy had a number of questions relating to robbery, but none regarding any racist element or language. There are a large number of references to the term, and it's the same racial slur, being used by the group, several relating to one accused. During his interview, he was asked about witness evidence claiming he had used this word. He denied that he would use this word and stated that he knows it to be racist. This is significant, and the link between this and the language used by him and others does not appear to have been made. Following the interview and arrest of the accused, the investigation team continued to interview witnesses, and all statements and resultant inquiries were submitted to the Crown Office and Procurator Fiscal Service. This included the statements of the significant witnesses who had heard language used where Simon was referred to by a racial term. It is evident that the investigation team placed little emphasis on the language used by the accused, and this additional information did not feature in the management policy file. And beneath that, this lack of emphasis could be interpreted in several ways as a lack of understanding of the importance of language used by the accused immediately after the crime, or of the racist nature of the language used, or that a single strand of evidence is sufficient to libel a racist aggravation. Whatever the reason, it is clear that this inaction had an impact on the direction of the inquiry and fundamentally led to a critical failure to meet the needs of the family. Is this a case that you remember at all, Mr. Logue?
I indicated, I think, in the last evidence session in April that I had a recollection of the case, and it was very general. I remember, I think, in the summer of 2011, dealing with the consequences, I think, of this report. I should stress I wasn't asked to address this in my witness statement either for the last session or this session, but because it was raised with me on the last occasion and I mentioned it, I've been able to look at a number of documents to refresh my memory of the case.
What I would like to do now is take you to the press release that bears your name. That is COPFS 06498. If we scroll down a little, please. So we see this is dated, sorry, just up a tiny bit, Thursday, the 25th of August 2011, and it's addressed to Private Secretary for the Lord Advocate, and it sets out the detail of a statement issued by the Crown Office on Monday, the 23rd of August. Death of Simon San, HMA against John Reid. Statement attributable to a Crown Office spokesperson. Lothian and Borders Police have today apologised for mistakes they have made in this case. In light of this apology, the Area Procurator Fiscal has offered to meet Mr San's family again to discuss any questions which they might now have. Am I right in understanding that you were the APF for Lothian and Borders at that point in time? So that would be a reference to you.
That's correct.
The Crown was alert to the question of racial motivation from the beginning of the investigation and raised the issue with the police at an early stage. After careful consideration of all the available evidence provided to the Crown by the police, Crown Counsel concluded that there was no evidence to show that the attack on Mr San was racially motivated. For a racial aggravation to be proved, there must be evidence to demonstrate the motivation for the commission of the crime. There was no evidence in law to support this, and this remains the case. There was evidence of a racial term used by the accused sometime after the crime, but this was not evidence of motivation for the crime. Notwithstanding this, the Advocate Depute advised the High Court when John Reid pled guilty to culpable homicide that it was the strongly held view of Mr San's family that the offence was racially motivated. And if we can scroll down a little. And there's a reference to a further part to the earlier statement attributed to Crown Office spokesperson. We can confirm the Lord Advocate will not be instructing an inquiry and is satisfied with the Crown's prosecution of this case. Mr John Logue, the Area Procurator Fiscal for Lothian and Borders, has offered to meet with Mr San's family to discuss any questions which they might now have. Now, are you aware of this press release? Do you recall this press release?
Only in very general terms. My recollection is supported by some of the material I've been able to look at since I last gave evidence. And so, to put it in context, this was a press release which was issued because there were lots of media questions being directed to COPFS in light of the statement which Lothian and Borders Police had issued about their conclusions about their work on the case. And in light of the media questions, it was felt appropriate after discussion to issue a statement clarifying our position, and that's why the statement was prepared.
It's apparent from the Operation Waymark report that we have looked at that Lothian and Borders recognised that their officers had failed to attach sufficient weight to racist language used after the attack and had failed to properly consider the possibility of a racist motive. It's also clear that the statements that were available to the police were made available to the Crown. And here we see that the Lord Advocate would not be instructing an inquiry and was satisfied with the Crown's prosecution of the case. I wonder if you can help us to understand, in light of the position taken by Lothian and Borders Police, the Crown's reluctance to review its decision-making, its handling of the case, with a view to potentially learning lessons.
I'm not sure that's an entirely accurate way of describing it. It wasn't a reluctance to review the matter. It was as a consequence of reviewing the matter that the Lord Advocate reached a conclusion that the scope of the police review was a narrow one. It looked at the police investigation, and as you'll appreciate, the Crown's investigation is separate and independent from that. And the Lord Advocate was satisfied that the Crown had not made the mistakes which the police accepted they had made, and that the Crown had taken a different approach. I should stress that this was a case which if I remember correctly, the case Mr. San was murdered, I think, in 2010, or killed in 2010, and I think the criminal case concluded at the end of that year. I was appointed in the early summer of 2011 and first became aware of it, I think, when the then Deputy Chief Constable advised me that he would be issuing a public statement about the conclusion of the police review, and therefore that was my first awareness of the issue, and that therefore allowed us to review the matter. My memory of it is that we continued to look at the matter sometime after the statement in discussions with Mr. Sands' family's representatives, and looked at some detail, for example, in relation to the circumstances in which the statements of the use of clearly racist language were used. And I have to say that in looking at it in detail, I do not agree with some of the characterization in the police report about the use of the language or the apparent certainty there were. When one looked at the detail of the statements available, it was clear that racist language had been used, but it was clear to us that it was not clear necessarily about the circumstances and precisely who had used the language. But it was absolutely clear and accepted by us that the language had been used, and that was taken into account when the decision about prosecution was made. There was a prosecution in this case, and it was clear to me in reviewing the case over that summer and into the autumn that the Crown did not make the same mistake that the police made in discounting the possibility of this being a racially motivated killing. Mr. Sands' family had been very clear with us at the very beginning that they regarded it as racially motivated, and my perspective in reviewing it was at that time that we therefore treated it on that basis as a racially motivated killing which needed to be examined and determined on the evidence what could be put before the court, and that's what was done. So this was a case in which there was consideration of the issues raised by the police and whether they impacted on the Crown's investigation, but the conclusion was that they did not, and it was for that reason that a decision was taken not to instruct an inquiry of the nature that was being sought. But that's not to say that there was no review and learning from it.
So your evidence is that there was not a reluctance to examine these issues, and there was in fact a review within the Crown Office. And so to the extent that the press release says we can confirm the Lord Advocate will not be instructing an inquiry, to the extent that that phraseology might give the reader the impression that there hadn't been a review and there wasn't going to be a review, is it perhaps a little misleading?
I will accept that. That was not issued without anyone considering the case or the circumstances. You would never issue a public statement of that nature without having first considered in some detail what the underlying issues were. But it was quite clear to us that this was a case where, in all of the meetings that the prosecutors had with Mr. Sands' family, and up to and including the conclusion of the case in court, where I think the Advocate Depute represented to the court Mr. Sands' family's views, the Crown had at the forefront of its thoughts the scope to identify evidence which could identify motivation. The issue which is drawn out in the police report is the distinction between evidence which can demonstrate motivation and other evidence which is clearly offensive and difficult to understand, but demonstrates the use of racist language. But the difficult question at the heart of that is the extent to which that can be relied on to demonstrate motivation. And that was fully considered in the analysis of the case for the final decision.
Thank you. Finally, I want to ask you about learning lessons in the context of the death of Mr. Bayo. Has there been a review, a lessons learned, a debrief, anything of that sort following the death of Mr. Bayo, with a view to looking at how the case was handled by Crown Office and perhaps learning lessons?
So there hasn't, we haven't commissioned a formal group specifically to do what you are describing. Partly that was because we, as I described earlier this morning, at the conclusion of the criminal investigation, it was very much our view that there needed to be a public inquiry of this nature, and therefore, first of all, that would be our focus in preparing for that and supporting the establishment of the inquiry. And secondly, I think it's a widely held view that our lessons learned should be informed by the lessons of the inquiry. So there will be, and I'm very happy to confirm in my current position, there will be at the conclusion of this inquiry a much more formal and structured approach to learning the lessons as identified by the inquiry. But that's not to say that we haven't, since 2015, incorporated changes which I think are informed by our own experience of dealing with the investigation. So I think those are important. And first amongst them would be the establishment of the Death and Custody Unit. That's within the specialised field of death investigations. We have identified over a number of years, and Mr. Bayou's case was part of that consideration, that deaths in custody, whether in police custody or in prison, bring very specific challenges. And we've therefore established in the last few years a dedicated team which guarantees that all of these cases are going to be investigated by the same small group of people who will then quickly build up their own personal experience, but also, for example, will become very familiar with all the legal issues and have well-established relationships with all of the key parties. So I think that is one factor that has changed since the death of Mr. Bayou. I think we can also point to general work to improve our deaths investigations. We've, since 2019, undertaken a piece of work to try and expedite and reform the way expedite the speed with which death investigations are carried out and reform the way in which they're done. And that has included the shift away from serial investigations to parallel investigations in the way that I talked about earlier. So I think those are two factors. And then I would add to those the personal, I think, learning which I have taken from my involvement with the inquiry thus far. And although I haven't discussed this with colleagues who've given evidence, I suspect they are doing the same. But I know that in giving evidence in April and preparing to come to give evidence today, there are a number of factors which I have begun to think about and focus on, which I think the question will be, can we make progress with those in advance of the inquiry concluding? And I would certainly not intend to wait until the inquiry was finished before we made progress with those.
Are you able to share with us what those factors are?
I can share my personal views, and I stress I haven't discussed these with anyone in the organisation. But I think in a death investigation of this nature, while it was obvious to us at the beginning that the need for criminality needed to be considered as a priority, as I've said before, that the question of race was absolutely at the forefront of our minds, I think for me, there is something about the way in which we have gone about it and the extent to which we were aware from other jurisdictions, and I'm principally considering England and Wales here, issues which had arisen. I think I might have said on the last occasion I gave evidence that this was the first case of this nature that I was aware of in Scotland. I think it is clear to me that we could have learned perhaps more by 2015 from other investigations in the United Kingdom. I think the question of having access to an appropriate expert in a death investigation on questions of race seems to me to be an issue that I'm not aware of us, and I could be wrong about this because, as I say, I'm just sharing personal thoughts at this stage. I'm not aware of us having done this, and if we have, then I'm mistaken in my view. But if we haven't done it, then I think that is something we could look at in future. The issues that we've talked about in terms of having a complete and full understanding of what it means to be a member of a minority ethnic community in Scotland and all of the ways in which that impacts on your life. I think there is something there we can do to help build up that knowledge and understanding, and begin then to also look at another area, which is the guidance issue you've touched on this morning. When I look at the PERC guidance that you showed me, I can see how those issues would come together. So I think I hopefully have been able to explain the context of the way in which we are treating our learning from this and give the inquiry the confidence that it's both an ongoing process, but one which will be very much informed by the results of the inquiry.
You said that at the conclusion of this inquiry there will be a formal and structured approach to learning lessons. Can you share with us what that will look like?
Yes, well, there are changes underway in the structure of the organisation at the moment, but I would intend that the Equality Board, which is chaired by Stephen McGowan, who's already given evidence, should directly and formally take on the responsibility for the analysis of the report and providing recommendations to the law officers and to myself on what changes are needed. And thereafter, I would look to all of the leaders in the organisation, not just those involved in the Equality Board, but all leaders to implement the changes which are required. It's very much a similar process to the one that we would use, for example, in relation to a report from the Inspectorate of Prosecution. So there was a report in April of this year in relation to domestic abuse, and we have adopted a similar structured formal approach which highlights the report to staff, raises awareness of it, identifies the actions we're going to take, and then monitors progress with those.
Thank you. Can you bear with me a moment, please? Okay. No further questions. Thank you.
Thank you.
Are there any Rule 9 applications? Mr. Logue, would you mind withdrawing to the witness room if I hear an application? Ms. Mitchell?
The questions that I seek to ask this witness relate to the Simon Sand case. Evidence in relation to the Simon Sand case was disclosed by the inquiry on Friday, and I was able to look at that over the weekend and this morning. So these questions arise as a result of that. Before I explain what the questions are, I explain the reason that it is said that Simon Sand is important. And it's because this inquiry has heard that lessons were learnt after the case of Chokar, and that things were put in place to try and ensure that when the Crown looked at issues of race, they were being properly considered. Mr. Sand's case came only a short period of time, I think a number of 2 years, before Mr. Bayo died in police custody. And at the time, Mr. Anwar had called upon the Crown to have an investigation so that in the future another family is not forced to fight for answers from the authorities. So it's against that background that the following questions are asked in relation to Simon Sand. The first is that the evidence that's been heard this morning is that the Crown Office did carry out a review of the matter, and as said by the witness, the Lord Advocate reached a conclusion that the scope of the police review was a narrow one. It looked at the police investigation, and as you'll appreciate, the Crown's investigation is separate and independent, and the Lord Advocate was satisfied that the Crown had not made the mistakes when the police accepted that they had made, and the Crown had taken different considerations in the analysis of the case. So, firstly, what I would like to ask, given the date of the report being issued by the police and the date of the Crown Office saying they weren't going to conduct a review were the same date, what time or when did this review take, and were they given a copy of this document in advance and undertook it? Secondly, the document that the Crown Crown received, the police report, indicated that the police had failed to take into account the import of the use of racist language, the history of the abuse that the family had suffered at their place of work and had been reported as racist and also non-racist abuse, previous convictions of the accused and racist sentiments expressed in general terms by one of them, a previous assault of Mr. Sand's cousin, of his nephew at the same place of work, and the view of the family that this was a racist attack. So my question is, did the Crown take these matters into consideration and still conclude that the matter was not racist? The reason in particular that I ask this was that it's clear that as a result of the review, the police accepted that they hadn't looked into various things that they ought to have looked into. And as a result of that, they could not have passed on to the Crown the information that the Crown would have needed to conduct a review in order that decision could be taken. So that's the second question. The third question relates to a second press release on the day that the press release comes out, which refuted the suggestion made by Mr. Anwar that there was evidence of a racial term used by the accused some time after that night, as described by the Crown. And that press release says that it was not made seconds after the incident, as the statement issued by Mr. Anwar states. And to point out that when the review took place, the view of the police in this regard was that the racist language was used by the accused immediately after the crime, and ask whether or not any consideration was given to the way the police had described this before releasing that report. The next question, which would be question number 4, or the next area that I would like to explore with this witness, is his view about the difficulty in capturing and presenting evidence of racist motive to the court. And he mentions that twice in his evidence today, where he says the type of information that you're referring to doesn't neatly fit in the criminal context into being admissible, relevant evidence for a criminal offence. And I suspect that is the heart of the issue that was ultimately being explored with Fiona Carnan. And it's to put to him that if the question is one of whether or not there's a racial motive, could the Crown, or should the Crown not simply consider raising evidence and taking any arguments in respect of relevancy that may arise, because if it's relevant it should be allowed, and in circumstances where they think there would be any difficulty in that regard, obtaining expert evidence, so expert evidence can be led in that way. The fifth issue that I would like to raise.
That last one is not really related to Simon Sands, it's more related to his evidence. As well.
That's correct, as a generality, yes. The fifth matter, going back to Mr. San, is does he accept that it was in fact the family that first raised and pressed the issue of a public inquiry with the Scottish Government, and that in all the meetings with the family, the Crown spoke of a fatal accident inquiry and never a public inquiry. And in that scope of those issues, was the existence, what was the public concern that the Crown had that it thought that a public inquiry was required instead of an FEI if it supported that, that proposition? Those are my questions.
Thank you, sir. I have a concern about certain of the questions that are proposed to be asked in relation to the Simon San case, and in particular, the second and the third and the fifth questions. The starting point is, of course, that the Simon San case is not part of the terms of reference which are before the inquiry, but I accept that there has been evidence in relation to that matter, and that indeed your Lordship may see some of that evidence as being relevant to the issues that he has to consider. So therefore, the first question, it seems to me, is unobjectionable. But it does seem to me that the second and the third, and indeed the fifth questions, take the inquiry towards being considering the question of the prosecutorial decision, and in particular the question of the basis upon which it was taken and whether it was soundly taken, which is of course something that is carved out of this inquiry in relation to Mr. Bayo's death, and it really ought not to be before the inquiry in relation to Mr. San's case. So I would take issue, sir, with the second, third and fifth questions.
Thank you. I'll adjourn to consider these issues. Well, let's come to the table.
So the prosecutorial decision had already been made. The question that I'm asking this witness about is the decision which he says was taken of the analysis of not making the same mistakes as the police had. So that could only have been done after the prosecution and after the reading of the report.
Very well. I shall adjourn to consider these issues.